Hello and welcome to this series of talks on the public access scheme for instructing barristers directly in the context of appeals. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. Let's talk about the powers of the appeal court. It can basically do whatever the lower court could do, subject of course to statutory limitations which may or may not exist. In general terms, though, it's got power to affirm or set aside or vary any order or judgment made or given by the lower court. It can refer any claim or issue for determination by the lower court. It can order a new trial or hearing, and it can make orders for the payment of interest or make a cost order. Now, I'm not going to say anything about jury trial appeals. My advice is to seek advice. There are some people who decide that they will not take no for an answer. On appeals, it's very important not to get carried away, because if the appeal court refuses your application for permission to appeal, or strikes out your notice, or dismisses your appeal, and if it considers that your application or notice, etc., is totally without merit, then its order has to record the fact that it considered your application, etc., to be totally without merit, but it also has to consider at the same time whether or not it's appropriate to make a civil restraint order. Now, these are orders which are made against essentially vexatious litigants. This has the potential to bar you from bringing further appeals generally. The details of restraint orders are set out in the procedure rules at Part 3.11. Let's have a look at the hearing itself. So the hearing is limited to a review of the decision of the lower court, unless there's a practice direction making different provision for a category of appeal, or the interests of justice, in the opinion of the court, requires that there should be a rehearing. It's not, subject to that caveat, a rehearing. So unless the court orders otherwise, it won't allow oral evidence or any evidence that wasn't before the lower court. It's going to allow the appeal if the decision of the lower court was wrong, or if it was unjust because of serious procedural or other irregularity. So if you're formulating your submissions for an appeal hearing, those are the areas that you need to focus on. It's entitled to draw any inference of fact which it considers justified on the evidence that's before it, and an important principle to bear in mind is that you can't rely on a matter which isn't contained in your notice unless the appeal court gives you permission. And that goes whether you're the respondent or the appellant. In statutory appeals, the court has power to hear any person, so any person can apply for permission to file evidence or to make representations at the hearing. They have to act promptly. The civil procedure rules allow for offers to be made which are not to be disclosed until liability is determined. Well, what happens to those on appeals? You're not allowed to disclose a Part 36 offer or payment to the judge of the appeal court hearing the application for permission or the appeal until all questions except costs have been determined, subject to the caveat, of course, that if the offer itself is relevant to the substance of the appeal, well, then you can, and if disclosure of the fact that a Part 36 offer or payment to court has been made is properly relevant to the matter to be decided, well, then again you can refer to it. But you have to be able to satisfy those tests of relevance, and you run the risk of aborting your appeal hearing and incurring a cost sanction if you do refer to the CPR Part 36 offer. In the case of second appeals, there must be an important point of principle or practice, or there's got to be some other compelling reason for the Court of Appeal to involve themselves. There's unlikely to be a compelling reason unless the prospects for success are very high. That's not necessarily sufficient for permission, but even if the prospects aren't very high, there may still be good reasons for believing that the hearing was tainted by some procedural irregularity, so that the first appeal was itself unfair. So the first appeal court can refer matters to the Court of Appeal on these grounds. And in the case of judicial review, where you're at the permission stage of seeking to apply for judicial review, which is always necessary, if you're refused, then you can apply within 7 days to get permission to appeal against that refusal of permission to bring your judicial review. And the Court of Appeal may give permission to bring the judicial review instead of granting the appeal or considering it as an appeal. So that is, as it were, a renewal of your application for permission to bring the judicial review. I want to say something about the role of the Court of Appeal officers. A barrister or solicitor who is a court officer assigned to the Civil Appeals Office is allowed to exercise the jurisdiction of the Court of Appeal without a hearing, but only in respect of incidental matters, or one in respect of which there's no substantial dispute. They can also dismiss the appeal or application if a party fails to comply with an order or rule or practice direction. They're not allowed to decide an application for permission to appeal or various other things, bail, injunctions, stays of proceedings other than a temporary one in circumstances where a Court of Appeal can't be brought together. If an officer makes that kind of decision, or any of those kinds of decision, then within 7 days of service of the decision you can ask for review by the Court of Appeal. Equally, any decision which has been made without a hearing of a single Court of Appeal judge or officer may be subject of a hearing to reconsider. Again, you have to make the request within 7 days of service of the decision. So I want to finish off by saying a few words about finding a barrister who does public access scheme work for an appeal. You really need to look for a specialist in the area of law with which you're concerned. Here are some sources of information. The Bar Council has a directory which contains a list of barristers who take on public access scheme work and the areas in which they work in public access scheme. If you're looking for somebody who is a clear specialist in an area, then it's best to look at one of the directories, such as Chambers and Partners directory, which lists specialisms and lists the leaders in specific fields, and you can see their biographies in there. And finally there's the Legal 500, which again lists leaders in their field and specialisms.